Hello, and welcome to David Boles' Human Meme. Today, we're going to talk about a prison story. This is not my story. This is the story of Gideon, a man you haven't met, but a man you need to know. In June 1961, there was a burglary in a Florida billiards hall. Someone broke in, stole some cigarettes, took some money. A witness came forward who said that Clarence Earl Gideon, a neighborhood ruffian, small-time petty criminal who'd been in trouble with the law many times before, had been seen in the pool room with alcohol and money. Police arrested Gideon based on that eyewitness account and charged him with petty larceny and breaking and entering. He was due to serve 5 years in prison if convicted. Gideon told the Florida court that was accusing him that he was too poor to hire a private lawyer. The court said to him, "Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I am sorry, but I will have to deny your request to appoint counsel to defend you in this case." And Gideon said, "The United States Supreme Court says I am entitled to be represented by counsel." Well, Gideon did his best to try to represent himself at trial. He called witnesses, he cross-examined testimony, and yet he did not win his release. He was ultimately convicted and sentenced to serve 5 years in prison. While he was sitting in prison, Gideon became self-taught as he studied the law. He believed what had happened to him in the state of Florida was wrong, and he was about to prove it by filing a writ of certiorari that Betts versus Brady, a 1942 case about this representation thing, was wrong. And Betts versus Brady was actually a violation of the 14th Amendment. And due process and equal protection under the law were at risk. Gideon was basically saying the Supreme Court got it wrong 20 years ago. In Betts versus Brady, it was decided that the refusal to appoint counsel for a poor defendant charged with a felony in a state court did not necessarily violate the due process clause of the 14th Amendment. So here's what Gideon wrote to the Supreme Court in a handwritten petition in pencil submitted on prison stationery. Petitioner was deprived of due process of law in the court. Evidence in the lower court did not show that a crime of breaking and entering with the intent to commit petty larceny had been committed. Your petitioner was compelled to make his own defense. He was incapable of adequately making his own defense. Petitioner did not plead nolo contendere, but that is what his trial amounted to. Very interesting argument. Nolo contendere means it's a process of what happens when a defendant in a trial, a criminal trial, accepts a conviction as if a guilty plea had been formally entered but no guilt was formally confessed. Well, after some deliberation, Gideon won. The Supreme Court of the United States reversed Betts versus Brady by arguing the Sixth Amendment's guarantee of counsel is a fundamental right for protecting a free trial. Justice Black said, "Reason and reflection require us to recognize that in our adversary system of criminal justice, any person hauled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided." Black also noted the noble ideal of fair trials before impartial tribunals, in which every defendant stands equal before the law, cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist. 2,000 people who had been convicted before Gideon in this same sort of wild, you are going to be punished without the advice of counsel, were released. Gideon himself was not immediately freed. He was provided a new trial with a right lawyer, paid for by the government, and after an hour of deliberation, after the trial, he was found not guilty by a jury of his peers. So the modern-day notion of a public defender, of the right to counsel, for those ideas, you may thank Clarence Earl Gideon. After his acquittal, Gideon went back to his small-time life and remarried. At the age of 61 in 1972, he died of cancer in Fort Lauderdale. He was later buried in an unmarked family grave in Missouri. A gravestone was later added with this inscription. It's a quote from a letter Gideon wrote to Abe Fortas, the lawyer who was appointed to him in his argument before the Supreme Court. Each era finds an improvement in law for the benefit of mankind. And that's my prison story. That's our prison story. The shared story of Gideon, a common man who found a wrong and made it right in the public well of power and prosecution. He stood up to stand down. Gideon was a man who examples the very best of us in what it means to be alive against land, man, steel, and the law. Thank you for listening. Be a human meme.